It is a common belief and in practice also that the Indian courts take lot of time to adjudicate upon the disputes between the parties. So what is the solution that a quick remedy can be attained by the parties or the private parties? One of the methods that was adopted by the legal people was that of resolving disputes by means of arbitration. So what is arbitration? How arbitration is beneficial, and if in case there is dispute with respect to appointment of arbitrator, then what is the solution? Hi, this is Advocate Prashant Kanha, and in this video I'll be talking about the issues pertaining to arbitration as I discussed before. So let us start with that. What is an arbitration? So arbitration basically in simple words means that there is a contract between the parties to resolve a dispute in a private manner by appointing a private judge who is known as arbitrator, but this private judge has all the powers of a regular judge, and the order which is known as award is enforceable just like an order passed by a regular judge sitting in a court of law. So the award that will be passed by the arbitrator will be executed as the decree of the civil court by following the process as given under Order 21 of the Code of Civil Procedure. So if in case the parties have the capability of appointing a private judge and also having the faith in that judge at the same time, having the faith in that arbitrator at the same time, that he will be adjudicating their dispute in a time bound manner within a limited time period, then they can have an arbitration clause in their contract. And if in case there is any dispute with respect to the performance of the contract or any other type of dispute within the framework of that contract, then in that scenario they can appoint their own arbitrator. They can also decide the procedure that will be followed. They can decide the remuneration that the arbitrator will receive. They can decide the qualification of the arbitrator. So this arbitration proceeding is also beneficial where technical or expertise of the judge is required to understand the sectoral technicalities. It is sometimes felt that the judge in a court may not having the expertise and he may not be able to comprehend the dispute when technicalities arise in technical contracts. But as an arbitrator, there are technical arbitrators also who can help in resolving the dispute in a better manner. Now, the arbitration clause can also provide that more than one arbitrator can be there. So, the party can assure that there can be a judicial arbitrator and the other person can be a technical arbitrator, or there can be panel of 3 arbitrators. So, the entire process of arbitration is settled and regularized by the party. Now, coming to the Indian Arbitration Act, the law itself provides that if the arbitrator has not been appointed and there is any emergency in the matter where an irreparable loss will be suffered, then in that scenario, even despite there being an arbitration clause, the party may approach a court of law directly without appointing the arbitrator and get interim measures under section 9 of the Arbitration Act. Then, as per the arbitration agreement, the parties will have to appoint their arbitrators. And if in case there is any dispute between the parties pertaining to the appointment of the arbitrator, then in that scenario, recourse of the court of law before the High Court or before the Supreme Court of India, before the respective Chief Justice, application can be filed for appointment of the arbitrator as per the arbitration clause. However, previous to that, a notice of 30 days has to be served from one party to another party to the contract that there is a dispute and appoint arbitrator for adjudication of the dispute. So this power under section 11 has been given to the Chief Justice of the High Court or the Chief Justice of India, so that the real intention of the Arbitration Act, that is to decide the disputes within a time bound manner, can be given effect to. Because once the parties enter into a dispute, then mutual cooperation is a thing which is least expected. Only the parties with open mind or parties open to resolve the dispute will appoint the arbitrator in the timely manner. But since there is no foundation, then in that scenario, one party may derail the entire arbitration process by not appointing or by not assenting or consenting to the arbitrator proposed by one side. So just to avoid the delay of start of the arbitration proceeding, which starts with the appointment of the arbitrator, section 11 provides that arbitrator can be appointed by the Chief Justice of the High Court and Chief Justice of the Supreme Court if in case the agreement or the arbitration is of international commercial arbitration nature. And when it is a national arbitration, then the High Court has the jurisdiction to appoint the arbitrator. So if in case you being a party are being harassed by the other side against which you have dispute and there is an arbitration clause in your agreement, but the other party is not appointing the arbitrator, then you can approach the High Court where of the jurisdiction, High Court of the jurisdiction under which your city or under which the contract has been executed. And if in case you are an international party or where the other party is an international party, in that scenario you can approach the Honorable Chief Justice of India in the Supreme Court and move such application. Now, with respect to arbitration clause, it is advisable that when you are entering into a contract with the party, then try at very that time try to suggest certain names in a seriatim manner, that in case of any dispute, following person should would be the arbitrator in this in seriatim manner, like on number one, if Mr. A is there, if he is available and ready to take the arbitration, then he will be the arbitrator. In his absence, by due to any reason, then Mr. B at serial number 2 will be arbitrator. In his absence also, by the person or the judge or the arbitrator at serial number 3 will be the arbitrator. So this is because when the parties are entering to contract, they enter that with open mind, and at that time it is possible to zero on a particular arbitrator or a particular set of arbitrators. But when dispute arise, then so many thoughts come in the party's mind, that may be with respect to the nature of the awards that have been previously given by arbitrators suggested by the other side, or there may be a sense of biasness or prejudice against some arbitrator. So to avoid such things, the name should be previously suggested, or another good option is to suggest that a particular arbitral institution will be conducting the arbitration. So now in our country also, in India also, many international or national arbitration centers have been established in Delhi, Mumbai, Hyderabad, and all many places. Such arbitration centers have been appointed. So you can mention that the arbitration shall be conducted by the particular arbitration institute. And when the dispute arises, you can refer the dispute to that arbitration institute, and then they themselves will appoint the arbitrator or refer or mark your matter to the particular arbitrator in their panel. And then in that very in their complex only, they will have a particular set of or a particular rules and regulations which will be binding for conducting the arbitration proceeding. They will have their set of arbitrators, and they will be conducting your entire case or resolving the dispute just like a court. And then the award given by the institutional arbitrator will be enforced like a decree of a civil court under Order 21 of the CPC. So this is all with respect to the topic that I tried to cover in this video. Hope this is helpful for you.